Hello, I'm Roger Citron, and I'm a professor at Touro University, Jacob D. Fuchsberg Law Center. This is a Touro Law Review podcast. We're delighted today to have with us Jason Gillmer. He is the John J. Hemmingson Professor of Civil Liberties at Gonzaga Law School. And we're here today because Jason was giving a paper this summer at the Law and Society Conference. I was fortunate enough to hear it, and I think it's an extraordinary story that more people should know about. And so that's why we're here today. Jason, thank you for joining us.
Yes, thank you for having me. I'm excited to be here.
Okay, and we always start with this one. Just tell us a little bit about yourself, please.
Absolutely. As you mentioned, I'm the John J. Hemmingson Professor of Civil Liberties at Gonzaga Law School. I teach in the areas of constitutional law, civil rights, torts, and I do a seminar on slavery and Jim Crow. So I would consider myself to be, as a scholar, a legal historian, but as a teacher and advocate, I do a lot in the area of constitutional law and civil rights. And I've been at Gonzaga for, going on about 12 years or so. I started my law teaching career at what was then Texas Wesleyan Law School. It's now Texas A&M Law School down in Fort Worth. So I've been at this for a little bit, and I've been loving every minute of it. So.
No, that's great. And really, I too share an interest in legal history. Anyone who goes through the podcast will see a bias in that direction in terms of subject matter. The article that you wrote, that you presented, that I was fortunate enough to see this summer, if I have the title correct, Litigating Slavery's Reach.
Exactly. Yep.
And that's the primary or principal title. And can you just, set the stage for us? This will take us into the 19th century, but just tell us a little bit about the case that's at the heart of your article.
Absolutely. So the case is called Re Perkins, and it was a decision rendered by the California Supreme Court in 1852. So we are going way back into the gold rush era. And it involved a slaveholder from Mississippi named Charles Perkins. And Charles Perkins was a young man. He came from a very wealthy family from Mississippi, but he came to California during the height of the gold rush, 1849. And he brought with him, he had one enslaved person with him at the time, and two more were sent out later. And the four of them, mined in the gold mines of California for a couple of years, until 1851, when Charles went back home to Mississippi. But notably and importantly for our story, the three enslaved persons that he brought with him didn't go back to Mississippi. They stayed in California. Now, the reason that Charles didn't bring these three men home with them is, of course, just speculation, but I think we can probably wager a guess, and it had, I think, a lot to do with the fact that California came into the Union in 1850 as a free state. So by this time, the case law is fairly well established that a slaveholder who brings slaves into a free state, voluntarily brings them into a free state, they become free. And this dates back to an English case called Somerset, and folks may have recall that case, that the air is too pure for a slave to breathe. It dates back to the 1700s, and that decision had been more or less followed in many southern states that had an opportunity to consider it. So Charles probably left him behind because he knew if he brought him back, they'd file a freedom suit and they would be free. But lo and behold, a year later, in 1852, California passed what's known as the Fugitive Slave Act, the California Fugitive Slave Act of 1852. And by its terms, it flew in the face of this well-established case law. And it basically said any slave brought to California before it became a state, which included these three people, remained slaves, right? So they didn't become free. So Charles, now again, he's back in Mississippi. He's got a cousin that's still out in California. He gets wind of this. So what does he do? He has the three men arrested during this sort of dramatic midnight raid. They're in a little camp up in a mining country, has them brought before a justice of the peace, and applying this new Fugitive Slave Act, the justice of the peace declares them fugitives from labor. So the case caused this huge uproar, and it was a stand-in for some heated debates that were happening on the national stage and would eventually be at play in probably the most infamous and controversial case in all of constitutional history, and that's Dred Scott versus Sanford. And the main issue was, what do we do when slavery runs headfirst into freedom? So in the article, what I do is I recreate this story. I follow this story. And I like to say from the ground up, and we could talk a little bit more about that if you want. But the idea is I follow Charles Perkins and the three men and other key characters in the case. I follow them as they make the decision to go west, as they spend some time in the gold fields. I then talk about the court case, and I talk about how it makes its way up to the California Supreme Court. And in that decision, in what is, I think, a sign of the politics of the day in California at this time, the court not only upholds the statute, the California Fugitive Slave Act, but declares, and again, here we are 5 years before Dred Scott, it declares that slaveholders have a constitutional right to bring their slaves into federal territories, in any effort to deprive them of their quote unquote property violates their due process clause. So it's 5 years before Dred Scott, and you basically have the same issue and the same outcome.
Well, how did you learn about the case? And in answering that, I hope you'll say a little bit about how well it was known, among legal academics, those in particular who would have taught, who teach what we, con law 2, that is the equal protection, and the Dred Scott case, that is when they, that type of, when they cover that material. How well known was this case in the legal academy, to your knowledge, and then how did you come into it?
Well, to my knowledge, not very well known, and I like to think that I've been in this field for a long while, and I've been focusing on other areas of the country, but I'll be honest with you, it never really occurred to me that California, of all places, would be litigating issues that were at the forefront of race and politics in the 1850s. That just wasn't in my experience. And I suspect that a lot of legal historians, with exception, obviously, of course, but a lot of legal historians, constitutional historians as well, wouldn't necessarily know this case. As I dug around, of course, there are a lot of, we'll call them Western historians, people who focus on the West, not necessarily legal historians, but Western historians who knew about this case, know a lot about this case. But among legal historians, our field, I don't think there's a whole lot of awareness of the case. Yes.
And this is, when I saw you speak, it was the first I had ever heard of it. And it really, I'm not exaggerating. It was mesmerizing because, of course, Dred Scott hangs over the con law course as,
Yes.
the worst of the worst, a case that continues to live in infamy. And then, uh, as you sort of literally, forgive the expression, dug into the case,
Uh-huh.
um, I'm curious about how you researched it, because I did read the article that's going to accompany the posting of the podcast. We'll link to that. And your footnotes are fascinating. There's a real array of sources there. And so, how did you, here I go again, how did you unearth the story?
Well, I could take you, I'll take you on the journey and stop me where you need to, and I can back up and circle around and do what I need to do. But I've made other efforts in other areas, Texas most notably, to uncover some of these stories about race, slavery, and the law. And one of the ways in which I begin the work, I should say, is I start just like everybody else would start. I'm on Westlaw, and I'm typing in the necessary search words, and so I found the Supreme Court case that way. And then, because the Supreme Court cases gives you a limited insight into what was really going on behind the scenes and in the lower courts, I work backwards, and I've got hold of the records from the lower courts that were filed with the appeals as they went up on appeal up to the California Supreme Court. And then, as I started digging around, I thought, this is an interesting case. I want to do more with it. I then started digging around and came across the papers of the attorney that argued the case in front of the California Supreme Court. And they are his papers are boxes and boxes and boxes of papers of.
Just to interrupt real quick, sorry, I apologize, but the attorney for
the three enslaved men. Yes, so he was representing them, challenging the constitutionality of the law. His name was Cornelius Cole, and he's sort of relatively well known in California history, because not only was he an early arrival during the gold rush, but he became he was a lawyer, obviously, and then he became involved in the founding of the Republican Party in California, along with Leland Stanford and a handful of others. And then he would go on to elected office, and he was there on the U.S. House of Representatives when Lincoln issued the Emancipation Proclamation. He was there in the Senate when they were discussing the 14th and the 15th Amendments. And so he's a notable figure in California political history. And so I came across his papers and was able to find some of his notes about the case. I found his argument. He would handwrite. Of course, he handwrote his argument out that he was giving before the court. And from there, so I've got the foundations. It's really intriguing. And now the rest is the story is just sort of building out, like figuring out who Charles Perkins is from Mississippi, figuring out as much as I can about the three people he brought with him. And then just sort of filling in the gaps in the stories as best I can with other primary sources. Census records, a lot of newspaper accounts, as you are aware, having read it, other diaries and letters from other folks that I think add insight to the experiences of the people I'm talking about. So a lot of fun stories too, one of the things I like to do when I'm researching these stories is I like to actually go to the location where the events were taking place. And so while I couldn't identify exactly where they were, I know they were in a county called El Dorado, which is outside of Sacramento. And I'm not from California, so this was kind of new to me, but you get to go down there, and there's this old town, that's restored town called Coloma. And we camped on the American River, and I got myself a little pan for gold, and got in the water and did a lot of that fun stuff, just to kind of have a feel for what the weather was like, and what the experience might have been, what they looked at when they were standing in the river. So I did a lot of that as well.
Yeah, and that was, we corresponded a little bit before, talking today, and I really loved the description of the labor, the work itself, and it it seemed uncomfortable, to
Yeah.
say the least. And there's a piece that ripples over, I think, in understanding. Um, uh, I do not say this in a callous way, or I want to say it the right way, but having three laborers whose work you could profit from, that you could benefit from, was a competitive advantage, a significant competitive advantage, for those mining or panning for gold. And so I just, if you could say a little bit more about that, because that really leaked out to me when I was reading the article.
Absolutely. And I think what your question touches on is the conversations that we're having at the national level and at the local level about whether California would enter the Union as a free state or as a slave state. The Southerners clearly wanted California and other areas acquired during the Treaty of Hidalgo and the war with Mexico. They clearly wanted them to be slave states, in part because at the time there were 15 free states and 15 slave states. Each one gets, two senators, and so whoever gets California is going to get control of the upper chamber, and so that's obviously strategically, politically really important. But Southerners too, they really were hoping to build this empire to the Pacific, because what it would do is it would allow them to not only extend the reach of slavery in the U.S., but now we're opening up markets across the Pacific, and they're an agricultural economy dependent upon selling goods, and boy, what a strategic advantage they would have there. On the flip side, of course, you have the origins of the, as Eric Foner would say, sort of the free labor, free soil, free man party, which would sort of morph into the Republican Party, about seeing the West, and California in particular, as this place where you didn't need connections. You didn't need to be successful in a prior life. You too could stand in the ice cold river and strike it rich. And so the last thing you wanted was competition from the slaveholding class, who, as you said, would have a competitive advantage over you. So a lot of folks who came to California were opposed to slavery, not because they were concerned about the rights of Black people, but because it interfered with the democratic ideal of white people.
Mm-hmm. And California, I want to make sure I have the history correct. When it became a state, it came in as a free state.
Yes,
I believe.
September
And
1850.
yes, and that was always true.
Always true. They were always a free state, but kind of, yep.
Yes.
Go ahead.
No, this is exactly what I'm going to say, because the case law, if you will, or from what I can recall from your article, that is, despite that, the fact that it was a free state, there was also, as the case you wrote about and we're talking about indicates, that there was a jurisprudence that was protective of slaveholders' rights as well. And so, before I mangle it any further, I want to let you sort of describe, if you will, the law case law and legislation in California, if you
No,
will.
you summed it up, I think, really well. And I maybe even more succinctly, we could say that slaveholders never gave up, right? So even though California came into the Union as as a free state, there was a sort of a constant push to either bring slaves in as if sort of an exception to the rule, right? Maybe establish a slaveholding colony within California, or there was even calls for a new constitutional convention, which would allow maybe a reconsideration of California being a free state, and maybe we could divide it in half, and we'll say that Southern California will be a slave state and Northern California will be a free state. So I think the California Fugitive Slave Act of 1852, which we're talking about, shows the influence of the slaveholding contingent that occupied political office in California during this time. They never got their constitutional convention, but they did get the Fugitive Slave Act, which protected the rights, the property rights of those people who were often in the legislature, or at least were powerful figures in the Democratic Party in California during this era.
And if I want to shift gears, if that's okay, because there's a piece of your article that talks about people of color and the way in which they viewed the legal system and the way in which they used or employed the legal system in efforts to, seek or obtain or enforce their freedom. And it isn't obviously intuitive, I think, that would necessarily be true. And yet that's what you describe in the article. And if you could say a little bit more about that.
Absolutely. So one of the things that maybe as a takeaway from my article is this idea of the laws written versus the laws experienced, right? I think many of us are familiar with that idea. But in the context of legal history, there's been a group of scholars, we'll call them cultural legal historians, that have been for a couple of decades doing less work with statutes and canonical cases and more work with kind of the local records, the county court records, and what those efforts have revealed is a number of doors have been opened, I suppose, into, if you will, sort of lived experience. So through these court filings, through these depositions, through this trial testimony, through these verdicts, you can hear the voices of the community in ways that you'll never hear when you're looking at statutes and canonical cases. And the voices include not just the powerful, right? They include regular people. They include people who weren't literate, people who didn't leave letters and diaries and didn't have political power, but it also includes women, it includes people of color, it includes enslaved persons as well as free people of color. So a group of scholars, and I'll put myself in this group, have been writing from this perspective for some time now. And again, I think to your question, as I get to it, what we're finding and what we're writing about and what we're discussing is the ways in which people of color shaped and reshaped the law, right? Now, it might have been an act of resistance. I think that's one way you can shape the law, right? It's just by refusing to abide by the law. So running away and fighting back and so forth. But there's also a surprising number of court cases involving people of color, and a lot of them are kind of run-of-the-mill stuff, right? A lawsuit over an unpaid debt, for example. But they could also be a really big case. It could be a freedom suit, like what we're talking about right now, where somebody's actual freedom is on the line. You know, Chief Justice Taney in Dred Scott has this infamous line where he says, you know, black people have no rights which the white man is bound to respect. If you're familiar with Dred Scott, he utters that language, and for a while we just sort of took that as a given. But the more we look at these cases from the ground up and the, you know, laws experienced, his statement to me feels more like kind of a slaveholder's fantasy rather than the sort of the realities of daily life. And so, you know, I would emphasize here that obviously people of color didn't win all their cases, and they lost more probably than they won, and freedom suits took a turn for the worse in the 1850s. But these are still examples of in which people are using the law and they are shaping the law. And I think it's important for us to give voice to these stories.
Yes, yes. And there's some questions where I kind of want to take us, you know, from the article into the classroom for you, and you know, into the United States today, and how the article relates to current developments. But before we do that, I guess I hate to sound like like my daughters, you know, circa 5-7 years ago. How does your story end? I want to make sure that we sort of tell this, you know, complete the story, unless, of course, you know, perhaps this has to come with a spoiler alert.
It comes with a spoiler alert, but I tell you what, one of the, if you notice, having read my article, that I write in the narrative, so I write stories. And when you're writing a story, you never give away the ending at the beginning, right? So if you will recall, I don't tell you how the story ends until you get to around page 50, right? So you can maybe figure it out, sense it as you're going along, but I never give it away. But for our purposes, since you asked, they unfortunately don't win. The slaveholder Charles Perkins convinces the California Supreme Court to uphold the Fugitive Slave Act, and in doing so, the court reaches that conclusion that Dred Scott would wait another 5 years to reach, in which they declare that slaveholders have the right to bring their quote unquote property, and here we're talking about human beings, but the court converts them to property. They have a right to bring their property to the federal territories, in any effort by Congress, and presumably later a state, to take that property from them would violate the Due Process Clause. So it ends with that conclusion of the court. How it ends in terms of the narrative, well, you can't really tighten up and close all the ends. I wish I knew what happened to the three men. They were declared slaves and were presumably on their way back to Mississippi at some point, but there's at least some reference. I haven't been able to independently verify it, but at least some reference that they may have escaped down in Panama. So as they made their way back through Panama, back up to the Gulf, and back to Mississippi. So we can always hope, but I don't know. I can't independently verify if that happened.
Yes. No, that's at least in the version I read, I think that's page 54. And it's tantalizing, to say the least. And you know, I did ask the question, and so we've discussed it. So, you know, perhaps that's my fault as a narrator in hosting the podcast.
No.
But let me ask now, because you mentioned at the outset, of course, you do teach constitutional law, and you know, there's sort of the narrow version of the question, which is, oh, so do you talk about this case in constitutional law? But I think there's a broader version, which is, you know, from this research and from your work on the case, has it influenced or changed how you teach con law when you come to the civil rights amendments and the build up to the Civil War and so on?
Yeah, absolutely. And I think I mentioned at the outset, there's three cases that I teach that are interrelated, and I have an opportunity to bring up a case like this. It's con law, it's civil rights, and it's the seminar on slavery and Jim Crow and the conquest of the American West. The latter, I think it's fairly easy to see that this would play a significant role in a seminar discussion. But the other two, it's not necessarily a guarantee that we're going to go back and spend time with some of these historical sources. But I do. With my civil rights class, I actually spend 2 full days with my own materials talking about the ways in which civil rights as we think of them today are selective in who they apply to and who they're granted to and how they're enforced. And so this case, I think, is a great illustration of how, when we think about due process rights, well, the rights of who, right? Who benefits? And it's clearly the white slaveholders who are benefiting. It's not people of color. And so I think that's a very important part of my civil rights class. With con law, obviously I'm teaching Dred Scott, but I spend a good portion of the class just on that case and these issues. And I like to think that having some understanding and appreciation of the freedom suits, and me able to do maybe a mini lecture or raise these issues with some students, gives them an opportunity to think about, well, as we talked about before, gives them an opportunity to think about how persons of color were actually much more involved in the law than a simple reading of Dred Scott would give you. So I do talk about the freedom suits, and I do talk about how, persons of color were in the courtroom challenging slaveholders in their right to hold them enslaved. And I think that's a valuable part of that history. Now, the other benefit of bringing up a case like this is it does allow us, again, to put Dred Scott into context. And, there's a lot of sort of talk about how Dred Scott was maybe the spark that sort of lit the fire for the Civil War, but this is really decades in the making, and it's happening at all different levels of the courts and different areas of the country. Bringing the West into the conversation is important.
And this may seem like the same question asked differently. I hope it's not, but you've touched upon the relationship between law and politics. If nothing else, in what you just said, that, well, sometimes we sort of oversimplify in law school, especially something that's complicated historically, just as a teaching device, so that we can get to the case and through the case and make the case coherent. And of course, I don't think it's in dispute that the causes of the Civil War are somewhat multifactored and complex. But the piece that I want to kind of follow up on here is, the relationship between law and politics. And in doing this historical research and writing this article, has your own thinking on the relationship between law and politics, has it evolved or has it changed? And if so, how? And if not, I think that's interesting to explore too. Whatever the answer is, I think it's an interesting, relationship to sort of tease out.
Well, that's a good question, and hearing you frame it that way is maybe got me thinking a little bit differently about it. And I'm not so maybe I'm not going to be able to give the best answer right now because I'm a little flat-footed. But how about maybe we could sort of answer it this way, and maybe answer from the perspective of California. So tell me if this gets to the question or not, or if it doesn't, maybe we'll just go with it. But one of the goals of the article was to place California into that national conversation about politics and about the laws of slavery. And California traditionally, at least, is kind of on the periphery of the discussion. The slavery, Civil War, Reconstruction, that's always been kind of a north-south, presented as kind of a north. It's like debates between Northerners and Southerners, and the California, to the extent it is relevant, is more about hopes and dreams, right, rather than being part of that conversation. But California, when people were first coming out, I would say that both law and politics were kind of absent, right? I mean, it is an area where at least the formal rules of law have not yet arrived. And also neither have politics. So people are it's a really interesting place in 1849, 1850, right? 1851. It's one of the most diverse places in the country. It's multiracial, it's multi-ethnic. It just would be really sort of a complex environment. And people are coexisting at the same time that they are fighting it out. And it's only with the arrival of the formal law, and by the formal law, I'm talking more about like actual courts of law, right? So in the mining countries, there were no courts of law, right? It was all just sort of a mining court, community court, where they have to resolve disputes. Somebody stole something. What are we going to do about it? Somebody's mining another person's claim. What are we going to do about it? And in that, in that environment, there is a lot of flexibility and a lot of fluidity. That's why I think you can see a lot of, even though Charles Perkins was trying to reenact his view of the world on the 3 enslaved men he brought, it wasn't going to work because they could just disappear, right? They can run away. So the arrival of law, formal law, the arrival of politics sort of reaffirms and reestablishes the old ways of thinking. So I don't know that answered your question, but I kind of got off on a tangent and had fun with it. So
no, I would say that the blinders that I had on in asking the question, and you may recall that I asked a version of this question when I, when that was, the Q&A part at the panel that you were on. But the blinders that I had on, of course, is from Robert Cover's Justice Accused, and the quintessential northern anti-slavery judge, or the northern judge who was personally opposed to slavery, but nonetheless enforced the Fugitive Slave Act. And so many people have heard me talk about Billy Budd that I'll stop there, with Shaw and so on. But what your answer it sort of exposed my blinders, because Massachusetts is a highly developed or highly civilized, in the sense of institutions of law and politics, that what I found so intriguing was the judge could feel one way and yet rule another way. But of course, you're talking about in California, it's all prior to that.
Yeah.
And yet there's the construction or the establishment of these institutions, and how does that unfold, and how does that relate back to the North, the South, that is the institutions of those from the states from where these people came before they got to California. So it's I think that with the question.
Well, I think that the people come first, and then the law follows. And we see that in a place like California, and it becomes I mean, they basically wholesale adopt a lot of the laws that you saw. If not slavery, they certainly adopted the restrictive laws on the rights of persons of color. So you couldn't testify in court, you couldn't vote, couldn't muster in the militia. We begin to see Jim Crow segregation on the streetcars long before you saw it in Louisiana and Plessy versus Ferguson, right? That's happening in California. So I think that's an interesting part of this story is, right, just the early flexibility, the early fluidity, and then it becomes much more rigid as people migrate and the law follows.
Yeah, yeah. And then I think this is my last question, but it sort of takes us into, here we are now in 2022, and, what does this article, what does this history, what does this story that you tell, how does it relate to, to the world we're in now, or the nation that we're in now? And I'll stop there with that, just with that question as an open-ended one.
So it's a great question. I love getting the question, but as easy as the question sounds like it would be to answer, it's actually one of the more difficult questions that could be asked of somebody like me who spends all this time in the 1850s. But I would say that what does it teach us? I would caution, I maybe begin this way. I would say that history is messy, right? It's full of stops and starts and, switchbacks and everything else. So I'm not one that would ever suggest that we're on sort of some lineal, arc of progress that things were bad then and they're much better now. I don't subscribe to that view, and I don't think that the work I do would ever support that position. If anything, I think what my work would show is maybe fits well with the CRT movement. I mean, we're hearing a lot about that these days as folks are, showing up at school boards and saying, don't teach CRT to our elementary school kids, right? Even though it's a law school upper level division theoretical course. But the basic idea behind that, of course, is that there's systemic injustices that have been built into the law, and that they've been built in, baked into the law centuries ago. And I think if my work shows anything is the truth of that, right? I mean, here we have a decision by the California Supreme Court, which turns human beings into property, right? It turns human beings into property. And that very idea is something that I think we're still trying to deal with, right? We see it in everyday life where folks aren't given the same advantages, opportunities, and experiences because of the fact that they were turned into property. And so I think in a way, just broadly speaking, it supports the CRT literature. But, we could also talk more specifically about things. And, one of the fun things that I've had about doing this work and writing about this particular case is it's given me an opportunity to really dig deep into California history. And again, I'm not from California. I'm an outsider. But I didn't know a lot of this stuff. And I've talked to people from California and they're like, what do you mean there was slavery in California? I had never known about that. And so in some respects, it's just an opportunity to tell a story and open people's eyes, right? And the New York Times did that really well with another Chief Justice from that era, right? Serenus Hastings, who was the first Chief Justice of the California Supreme Court, and he founded UC Hastings College of Law. Well, here we are in 2022. The New York Times started writing about it a couple years ago or a year ago. And then the students got into it and the alumni got into it. And Hastings, as that article detailed, just committed genocide against Native populations. And so exposing some of this history, I think, allows us to tell a lot of different stories, right? It's a multiracial, multi-ethnic society. We can tell these stories, give voice to people, but it's also exposing some of the people that we need to expose, right? And Hastings, as you probably know, and as our listeners might know, UC Hastings has decided to change the name. I don't know that they've arrived on a new name yet, but they're going to, because they don't want to be associated with somebody who committed genocide. And so I think that part of the reason for doing this is just to give people a new lens through which they can view the past.
All right. Well, I think that's actually a very appropriate point on which to conclude. Is there anything else that you want to add, or would you like to have that be your closing remarks?
I would just like to thank you for giving me this opportunity to share my work, and I hope people find it interesting. And boy, there's a lot of stories. As I'm doing this research, there's a lot of other stories that I've uncovered and hope to tell in some future work as I think about narratives and how to keep them all together. But there's a richness of opportunity out there, and I'm eager to share it.
Well, you've started down this path with a fascinating story, and I thank you for taking the time for talking about it with me. And I hope to see you again soon.
Yeah, thank you, Roger. This has been a lot of fun.